Ireland is often referred to as the Silicon Valley of Europe. We currently host some of the largest technology companies in the world, and as a result also play host to vast amounts of data, much of which is stored in data centres across the country. Data privacy and protection law is a growing area of legal development and has seen much debate over the last number of years with regard as to how data should be regulated and people's privacy be protected. This is not a development unique to Ireland, and the importance of data protection law has grown exponentially around Europe thanks to developments in technology. Sweden was the first country to implement data protection law back in 1973, and since then both domestic and European law has sought to maintain safeguards on people's data as the technological age has progressed. The most recent development in this area is the landmark piece of European law, the GDPR, or General Data Protection Regulations. Adopted by the European Parliament back in 2014, the GDPR will come into effect in May of this year and will have a wide-ranging impact on the law in both Ireland and in the EU member states. This presentation aims to outline Irish data protection law, looking at both domestic legislation and European directives and regulations. We will then illustrate the various rights of data subjects and the responsibilities of data controllers as set out in current legislation before providing a basic analysis of the impact of the new GDPR on Irish individuals and organisations.
The law on data protection began in Ireland with the introduction of the Data Protection Act of 1988, a piece of legislation which created the Office of the Data Protection Commissioner, established the Register of Data Controllers, prohibited the transfer of personal data outside of the state, and most importantly, set out for the first time the rights of data subjects with respect to their personal data. Later, data protection law in Ireland was amended and updated in 2003 in order to bring Irish law into line with the European Directive of 1995, which we'll discuss later. The 2003 Act introduced several changes, one of which was the granting of the power to conduct inspections of organisations to the Data Protection Commissioner, something which enabled the Commissioner to ensure greater compliance with the various provisions of the 2003 Act. It also brought in changes that allowed for the transfer of data outside of the state, but only to countries in the European Economic Area, with adequate data protection laws, again in line with the European Directive. These two major pieces of legislation form the basis of data protection law in Ireland and set out the rights and obligations of data subjects and processors, as well as the various mechanisms for dealing with things like requests for data to be deleted, amended, or for copies to be
mentioned. The 1988 Act established the Office of the Data Protection Commissioner, which officially began operations in 1989. The DPC has the important role of policing privacy and data law in Ireland, ensuring that the rights and responsibilities set out under statute are vindicated and upheld. One of the central functions of the Data Protection Commissioner is the investigation of potential breaches of the Act. This investigative role can come off the back of a complaint by an individual, but may also be of the DPC's own initiative, if they believe an organisation may be in violation of the law, something which is set out under Section 10 of the 1988 Act. Under the same section of the Act, the DPC can also order the correction or deletion of any data held by the data controllers, and this is done through the issuing of an enforcement notice. In carrying out these aforementioned functions, DPC is also given the power to demand any information needed from any person. That is done through the issuing of an information notice. Another one of the major roles of the DPC is the maintaining of the Register of Data Controllers, which keeps a list of all data controllers in the state, with the exception of those organisations and controllers exempted by law, for example a school. All of these functions of the DPC help to ensure that the rights of data subjects are protected and that the obligations of controllers are enforced.
The 1988 Act and the subsequent Amendment Act, data subjects are granted several important rights with regard to their personal data. One of the most important of these is the right to access a copy of any personal data held on you. While a fee may be charged to get a copy of the data, under law it can cost no more than $6.35. A data subject has the right to remove their details from any direct marketing list by contacting the data controller and requesting that their data be removed. Further, they also have the right to ask the controller to amend any factual errors that their data may contain, as well as having the right to have data be deleted if the controller has no valid reason for holding it. In all cases, the controller must respond within 40 days to either do as is asked or to explain why the subject's request is being refused. A data subject has the right not to be subjected to automatic decision making too. While these are the main rights currently, as we will discuss further, the new GDPR will include new rights for individuals and their data.
Irish law also imposes several important obligations on data controllers which are set out under the two acts. One of the most important is that data is obtained openly, honestly and fairly. This means that when a data controller wishes to obtain information, they must identify themselves, what they want and the purpose of the desired data. This ensures that individuals are able to control what data they give away and prevents controllers manipulating or tricking people into giving away data they don't want to share. Once collected data is no longer required and there is no valid reason for keeping it, a data controller is obligated to delete it. Equally, they must keep any data they are keeping secure. This involves having appropriate security measures and preventing data leakage through basic errors and flaws. Finally, as said by Kevin, a data subject may request a copy of their data and a controller is obligated under law to provide it. Any data must also be clearly explained and it must be provided within 40 days of request.
Much of law in Ireland with regards to data protection stems from EU law. The European Union has enacted several measures which help to protect and regulate the personal data of European citizens. As we have already discussed, the 2003 Amendment Act in Irish law was introduced to bring Ireland into line with the Directive 95/46/EC, which set out a number of principles regarding the criteria that make up lawfully obtained data, as well as establishing special categories of data, which encompasses personal data regarding race, religious beliefs, political opinion, etc. As the world further progressed into the 21st century, technology advanced rapidly, with the rise of social media and other new online platforms which allow for the mass sharing of personal data. This technological development mandated new and updated data protection law, and in 2009 the long road towards the GDPR began.
General data protection regulations, which are set to come into force on the 25th of May 2018, can trace their origins back to January 2012, when the proposals for the GDPR were first set out following a public consultation on the issue. The idea was to update legislation for the new digital age and to further help the establishment and functioning of the EU digital single market, a concept emphasised by the European Commission's President Jean-Claude Juncker. From then, the GDPR made its way through the European legislative system until it was adopted by the European Parliament and the Council. The EU's Working Party, which originates from Article 29 of the 95 Directive, and is consistent of all of the data protection organisations across Europe, then issued its plan of action for implementation. Also occurring during this time was one of the most important cases in the area of data protection in Europe. An Austrian lawyer, Max Schrems, complained to the DPC about data transfers from the EU to the US under the Safe Harbour Agreement. His complaint was escalated all the way from the High Court to the European Court of Justice, which then struck out the Safe Harbour Agreement, which facilitated data transfers between the EU and US. All of this led to the need for a new regulatory order, which was to arrive in the form of the GDPR.
The impact of the GDPR will be major for individuals and will strengthen the rights afforded to European citizens. Under the GDPR, individuals' rights to request copies of their data held on them, obtain details on the processing of their data, and have data be corrected or updated will be strengthened further, while several new rights will now exist. For example, the right to have one's data transferred to another organisation from its current controller, something known as data portability. Central to the GDPR is the principle of transparency. What the regulation sets out to do is to ensure that data is processed and held in a way that is open and allows data subjects to see how their data is being collected and used, as well as allowing them to access any data held on them and have it presented in a clear and straightforward manner. Rigorous new standards will be placed on controllers to ensure that safeguards and accessing data is prioritised, and this will protect data from being transferred to countries and even specific regions outside of the EU which do not meet the adequate data protection standards. A key right to be guaranteed under Article 17 of the regulation is the well-publicised right to be forgotten, also known as data erasure, which allows the subject to request that all data be erased and further use of data be halted by controllers and third parties.
Under the regulation, businesses and organisations will see most of the changes. One of the biggest new changes deals with online and digital consent. Many of us have seen complex terms of service agreements that we often agree to without reading. Under the GDPR, this type of agreement will no longer be allowed, and consent to data collection must be stated in a clear and separate section. With regards to data requests, the 40-day waiting time will be reduced to under a month, and the charge of €6.35 will only be applied if it is proven that data was administratively expensive to hand over. The DPC will now have a suite of new powers in order to tackle non-compliance, notably to set fines up to €20 million or 4% of global profits for serious breaches. There will also be a mandatory presence of a data protection officer whose job will be to maintain internal records and ensure compliance with data protection legislation. Overall, the impact on organisations will require some changes to business practices, but will be of major importance in upholding good data protection practices and ensuring individuals' ability to exercise their rights.
As we've seen, the area of data protection is rapidly changing in order to keep up the fast-paced change of technology and data sharing. From basic beginnings, data protection law has rapidly grown in both the physical scope of its ability to regulate and control dealings with data, but also its importance to individuals and businesses. There's now a growing awareness among people of how much data they share and, wisely, what that data is used for. With this growing consciousness, it is of the utmost importance that both European and Irish law follow apace and ensure that the rights of data subjects are vindicated, upheld, and protected.